I'm Hazel Gendine of the Faculty of Laws. Very pleased to welcome you all here this evening to hear the inaugural lecture of Professor Paul Mitchell. On these occasions it's customary, even though many of you will know Paul very well, on these occasions it's customary to give a bit of biographical detail and to give you a sense of the path they took to reach this point. Paul started off reading law at Magdalen College, Oxford, where he was taught Roman law and legal history by David Ibbotson, who's currently Regius Professor in Cambridge and is here this evening, so welcome, David. Paul then did a DPhil, supervised by John Davis, who is also here this evening, and on the historical development of fault in defamation. Paul's first teaching posts were college lectureships in Oxford, at Magdalen, Somerville, St Hilda's and St Catherine's, and at the same time he gave his first lecture. He tells me that his first lecture was on the subject of defamation. Was it because nobody else wanted to do it? And it apparently took place in Seminar Room C in the Oxford Law Faculty, and I'm giving that detail because some of the students who came to that first lecture are actually here this evening. And I think the fact that they've turned up this evening, I think 3 of them who are in practice, is a tribute to Paul's lecturing skills and his ability to capture the imagination of his students, something that we know well in the law faculty here, and we're delighted that you're joining us here this evening. After his stint at Oxford, Paul, I had in brackets sensibly moved to London. I then crossed out the sensibly, but at least I told you I did that. He came in 1999. He had a year at Queen Mary. He then started at King's in 2000. And at King's, Paul was lecturer, senior lecturer and reader before in 2010 finally we lured him north to UCL. Paul's well known around the world, having held posts of Senior Visiting Fellow at the University of Melbourne, Distinguished Visitor at the University of Queensland, and continues to be a visiting lecturer at the University of Hong Kong. Paul's research focuses on the law of obligations in both current and historical perspectives. It includes a monograph, The Making of the Modern Law of Defamation, which he published in 2005, articles in journals such as the Law Quarterly Review, Oxford Journal of Legal Studies, Public Law, Sydney Law Review and University of Queensland Law Journal, and contributions to Jitty on contracts. Most recently, he was part of a new editorial team that recast Gough and Jones on unjust enrichment. Paul's interest in bringing together legal history and current law scholarship prompted his involvement in the Landmark Cases series, now in its 4th volume on equity, which he's edited with Charles Mitchell. He's currently working on a monograph on the history of tort law in the early 20th century. We're thrilled that he's joined the law faculty. He's the most popular member of the faculty, and we are all eagerly awaiting to hear his lecture this evening on patterns of legal change. So this is your moment, Paul. Take a stand.
Thank you, Hazel. Haven't done anything yet. Anyway, I'm delighted to see you all this evening. Thank you so much for coming to this occasion, which makes it very special for me. My subject this evening is legal change, and my theme will be to suggest new approaches to understanding how change takes place in law. I shall use examples from English private law, but the themes I identify can be applied more widely. As most of you will know, a large part of my research has been concerned with legal history, and you may not have been entirely surprised to be invited to a lecture by a legal historian about how the law has changed over time. Legal change, however, is far too important just to be left to legal historians, because law is in a constant state of change. Expositions of what the common law actually is, whether in judgments or in books, are constantly and deliberately interwoven with claims about what it was and what it could, should, or ought to be. In these expositions, statements of what the law is may either paradoxically justify themselves by reference to what the law was, or define themselves against an earlier position. Statements about the future, similarly, tend to be made for the purpose of contrast with an eye on the present. What the law is explained by distinguishing it from what it might become. The future may even be presented as controlling the present, as when it is asserted that only Parliament can alter a particularly unsatisfactory area of the common law. Statutory materials might at first sight appear to have a more straightforward role in legal change. We might anticipate that they would need no support from the past and take it upon themselves to define both the present and the future. It turns out, however, that statutes, like the common law, have a sophisticated relationship with both the past and the future. Their meaning can be gathered only by simultaneously relying on the past as a source of information about matters like the meaning of concepts, and at the same time their effects are identified only by rejecting the past so as to identify what exactly is new. In other words, as law students, academics and practitioners, we are all in the business of making sense of legal change, whether we like it or not. Despite the centrality of legal change to an understanding of what law is, inadequate attention has been paid to both its processes and structures. We all know, of course, that judges can change the common law by reformulation, although they have to be careful how they do it. We also know that Parliament can change the law by legislation. And most of us grudgingly accept that even the most brilliant academic exposition does not in itself change what the law is. That, however, is a crude and very basic account. It tells us nothing about where ideas for change come from. It tells us nothing about why some ideas fail and others succeed. Nor does it give any sense of interactions between different agents in the process of change. It is only by casting light on these and other issues that we shall be able to produce anything like an accurate picture of the patterns of legal change. Let me first look at judicial change. There are many fascinating aspects of judicial reasoning, but this evening I want to focus on two: how judges make use of the past and the conditions under which they produce their judgments. Turning to the judicial use of the past, judgments beautifully illustrate the point that the common law is a recursive system, that is, a system which operates by the repeated application of its processes to the products of its own earlier processes. Thus, in the classic common law judgment, a very large proportion of the text consists of the summarising, excerpting and processing of previous judgments. The product of this operation is the articulation of principles that govern the current case. The past apparently controls the present. But if it were really true that the past controlled the present, there would be no scope for legal change through judicial reasoning at all. In fact, as we all know, the techniques of interpretation allow different judges to come to different views about what the law was or is. Of course, we might suspect that judicial accounts of the past are coloured by judicial perceptions of the present. But I would go further, and in doing so would draw on the distinction first made by H.L.A. Hart between the internal perspective and the external perspective in his analysis of legal systems. I would argue that the distinction between internal and external perspectives applies equally to accounts of legal history. As Hart pointed out, there might well be a discrepancy between statements about the past existence of a legal system made by external observers and ostensibly similar statements by officials participating in it. Thus, it would be perfectly possible for internal participants to assert that the system had existed continuously, whilst external participants could disagree. The same is true for assertions about legal history more generally. External perspectives have no implicit commitment to the continuity or authority of the object being observed. They can, therefore, afford to emphasise discontinuities and inconsistencies. Internal perspectives, on the other hand, in our example, judicial accounts of legal history, have a very different purpose. These statements are not merely aiming for accurate description. They are made to legitimise subsequent statements about what the law is by making the past consistent with, and indeed appear to lead inevitably to, an assertion about the present. Let me take two recent examples. My first example is the Court of Appeal's decision in Customs and Excise Commissioners against Barclays Bank, where the court held, in reasoning later reversed by the House of Lords, that there was no distinctive test of voluntary assumption of responsibility for ascertaining the existence of a duty of care in negligence. The Court of Appeal identified the relevant historical starting point for analysis as being the 1990 decision in Caparo Industries and Dickman. That starting point excluded the House of Lords' 1963 decision in Hedley-Byrne and Heller, which would have provided the major authoritative support for assumption of responsibility as a distinctive test. An even better starting point would have been the early 18th century decision in Coggs and Bernard, which articulated a broad, general principle of assumption of responsibility. Deciding where history starts in a system where the past controls the present fundamentally affects the end result. My second example is the House of Lords decision in Jameel and Wall Street Journal. In that case, there was disagreement over whether the defence recognised in the earlier decision of Reynolds and Times newspapers was a new jurisprudential creature or part of the existing defence of qualified privilege. The issue was important because if the Reynolds defence really was a new jurisprudential creature, it did not need to be governed by the restrictions, such as the limiting role of malice, which applied to traditional qualified privilege. Although the point's not entirely clear, the majority seemed to favour categorisation in terms of traditional qualified privilege. What is particularly interesting for our purposes is the different appeals to history that were made to justify the opposing positions. Lord Bingham and Lord Hope took a close textual approach to the Reynolds case. Lord Hoffman and Lady Hale adopted the position that recent developments had moved the law towards recognising a new defence. Lord Scott regarded the traditional test of qualified privilege as, in itself, incorporating the public interest. These three very different approaches to the past produced different results. Lord Bingham and Lord Hope's archaeological approach, focusing on the text of Reynolds, indicated that traditional qualified privilege applied. Lord Hoffman and Lady Hale's more teleological approach regarded Reynolds as part of a journey, the ultimate destination of which was a new legal category. Lord Scott's approach was perhaps best described as nostalgic. On his account, the decision in Reynolds was restoring the common law to its former, more liberal position. For him, Reynolds was part of traditional qualified privilege, but it was a broader concept of traditional qualified privilege than had previously been understood. Of course, it would be a mistake to deduce from the speeches in Reynolds that the law lords involved were members of different historical schools of interpretation. There's every reason to think that judges take the approach to history that seems most appropriate to them in the situation with which they're faced. Rather, the point is that the construction of the historical context into which the analysis of current law will be placed is, in itself, a crucial matter of judicial choice. In developing a classification of the different approaches to history and judicial reasoning, much can be learned from theories concerned with how recursive systems operate. As some legal theorists have recognised, a system may make use of the products of its own previous processes, a phenomenon known as feedback, in two fundamentally different ways. In the first, positive feedback, later operations of the system follow a tendency or trajectory established by earlier operations. Thus, for example, the system of bidding at an auction moves the amounts offered in only one direction. In the second kind of feedback, negative feedback, the system reacts against its earlier operations in order to maintain a constant state. The thermostat on a heating system provides a simple example, although not for those of us who work in Bentham House. I mean, it's designed to balance out previous operations of the system in order to retain a constant temperature. Depending on whether a system is operating on the basis of positive or negative feedback, therefore, a previous product of the system will be either reinforced or held in check. The same fundamental distinction between positive and negative feedback can be seen in judicial approaches to history. To take the same example of Jamil and Wall Street Journal, Lord Hoffman's and Lady Hale's approach typifies positive feedback. Lord Bingham's, Lord Hope's and Lord Scott's, negative feedback. As the House of Lords speeches in Jamil also show, different approaches may be taken within these broad feedback settings. Whilst Lord Bingham and Lord Hope's use of negative feedback had the modest aim of keeping the law in the position that it had occupied after the House of Lords decision in Reynolds, Lord Scott's approach was more ambitious. His concern seemed to be to establish that when the courts recognised a defence of qualified privilege for publications by newspapers, they were in some way returning the law to the pure archetypal state in which it had existed at the creation of the defence of qualified privilege in 1834. There is perhaps a sense that Lord Scott felt that the law on qualified privilege should be restored to the uncorrupted state in which it had initially been conceived. Historically, that's rather a difficult claim to make good, but as I've already suggested, such a claim makes far more sense when we remember that it is an internal statement about legal history, which is made by a participant in the legal process who may well wish to emphasise the law's continuity. Once it is appreciated that judges have choices about where history starts and about what kind of historical narrative they wish to construct from the historical cross-section they have chosen, it becomes easier to understand how common law can be both apparently determined by history and capable of constant change. Let me now turn to the conditions under which judgments are produced. Here, my general theme is that judgments should not be seen as freestanding artifacts, independent of the processes of production that have given rise to them. Rather, our starting point should be this: the law report of a case is an imperfect and incomplete record of an event, and we should not forget what is missing. Judgments respond to counsel's arguments, but increasingly, arguments are not reported at all. We read only the end of the conversation. Even where arguments are reported in series such as the appeal case reports, what appears is a drastically telescoped version of what happened. The discrepancy between the length of the printed argument and the number of days that it apparently took to deliver makes this clear, and is confirmed by reference to other sources. For instance, Lord Reed's notebook for Hedley, Burn and Heller shows the care with which counsel took their lordships through the authorities, and also shows how Lord Reed's thoughts developed in the course of listening to those submissions. A further factor invisible in contemporary law reports are judicial interventions in argument. Counsel's responses to those interventions often were, and indeed are, crucial, but again, current reporting conventions suppress or minimise them. For instance, Alan Patterson once observed over 100 interventions on the first day of argument in the House of Lords in the exemplary damages case of Castle and Broom. None of those interventions appear in the law reports. As a result, the distinctive conversational style of common law adjudication is obscured. Paradoxically, the best way to get a sense of how courts actually decide cases today is to read reports of cases from 1865. It's kind of back to the future approach, where far more of the exchanges between judges and counsel are preserved. Two other factors in the production process are also rendered invisible by treating the texts of judgments as freestanding artifacts. The first is the importance of time. Literary scholars have long acknowledged and debated the impact of commercial pressures on authors' works. But despite judicial expressions of anxiety about the impact of time pressure, only legal historians have, at least thus far, really started to explore the issue. For instance, the 19th century English judge Lord Ellenborough has something of a mixed reputation. Lord Campbell, who as a junior barrister reported many of Ellenborough's decisions, hardly helped by saying that by the end of his time as a law reporter, he had what he called a drawer full of bad Ellenborough law. He retained these curiosities for his own amusement, but considerately refrained from publishing them. However, once we realised that Ellenborough had to deal with at least 10 jury cases per day, indeed, he was once described as rushing through the lists like a rhinoceros through a sugar plantation, a more sympathetic and realistic reading of his judgments is possible. A factor linked to time pressure is our changing expectations about what the judicial process should produce. Today, there's no such thing as an unreported High Court, Court of Appeal, or Supreme Court case. Everything is available online. It takes a bold and, we might think, well-established judge to say today, as Sir Anthony May did in the recent decision in Cleveland Bridge and Multiplex Constructions, that he was deliberately not producing a reportable judgment. The role of the judge as author, however, is a relatively recent development. It can be linked to two phenomena. First, the increase in printed law reports from the late 18th century onwards, particularly Burroughs' reports of the decisions of Lord Mansfield. Secondly, the rise of judicial biographies, most notably Lord Campbell's Lives of the Lord Chancellors and Lives of the Chief Justices, in which judicial style and creativity were celebrated. It's perhaps not entirely coincidental that one of the earliest references by a judge to the importance of getting the text right for publication came in 1868, 3 years after the introduction of systematic law reporting. By the end of the 20th century, the significance of the text had become dominant. It is nicely illustrated by a detail in Derbyshire County Council against Times newspapers, decided in 1993. There, the House of Lords was invited to rely on judicial reasoning given in Williams and Manchester Corporation. Right. That wasn't in the script, right? The crucial sentence appeared in the Law Times report, but not in the Queen's Bench reports. The House of Lords refused to rely on the Law Times on the ground that whilst the Law Times contained the more accurate report of what the judge had actually said, the official report probably reflected the judge's revised view. In other words, the inaccurate report being the better text was what counted. We should also note that not everyone was delighted about the rise of the judge as author and the judgment as text. In a light-hearted lecture with a serious message given in 1969, Lord Justice Russell having emphasised the prominent role of gin and Sussex train timetables in the writing of judgments in the Court of Appeal, reproached his academic audience for reading too much into the language of unreserved judgments. The pressures under which they were produced, he explained, made it inappropriate to treat them as the product of precision instruments. Essentially, Lord Justice Russell was reminding his readers that by treating reported judgments as texts, they were losing sight of the conditions under which those judgments were produced. They were also forgetting that the primary audience for the judgment was the parties, not the legal academic reader. The final factor I would like to highlight concerns discussions between judges after argument has ended. It is all too easy to read the 3, 5, 7, or even 9 speeches of an appellate court as 3, 5, 7, or 9 individual efforts, unless we are told otherwise. Occasionally, we get a glimpse of the reality. Lord Macmillan redrafting his speech in Donoghue and Stevenson, almost certainly at Lord Atkin's behest. Lord Devlin taking the initiative in Hedley Burn and Heller, so as to ensure that general principles were laid out, even though they were not necessary for the decision in the case. Correspondence between judges in the 1930s, showing that Lord Atkin's enthusiasm for legal change was notorious, and that attempts were made to compose panels to ensure that he was outnumbered. None of these insights can be gathered from the reports themselves, but each allows us to read the report differently. The apparently placid conservatism of the now forgotten House of Lords decision on medical negligence in Lindsay against Marshall looks very different when we know the efforts that were gone to behind the scenes to outnumber Lord Atkin and prevent him from repeating Donoghue and Stevenson. Similarly, Lord Devlin's statement in Hedley Burn that he was prepared to adopt any one of your lordship's statements as showing the general rule sounds rather meek, almost disinterested. In the context of the judicial process revealed by the archives, however, it becomes an ironic comment on the fact that there were so many principles for him to choose from. Behind these disagreements between judges and debates over panel composition lie 2 more fundamental questions. How do different judges see their role, and why is there a difference? These are questions to which the answers often lie outside the official texts of judgments, in places such as extracurial, autobiographical, and biographical writings. English law is very rich in these materials, of which surprisingly little has traditionally been made by scholars. Sometimes they may contain a direct explanation of otherwise implicit assumptions about when legal change is appropriate. Lord Reid, for example, once set out in a lecture which parts of the law he felt were most suitable for judicial development. Other materials may reveal judicial perceptions about the effects of judgments, as when Lord Gough commented that the main effect of an earlier House of Lords case had been the pointless construction of excessively deep foundations for buildings. Biographical and autobiographical information may also explain decisive judicial assessments of issues, such as whether legislation or common law development is most appropriate. For instance, attempts to reform the law on the consequences of frustration stalled in the late 1930s, when the then Lord Chancellor, Viscount Caldecott, became convinced that it would be too politically difficult to steer a bill through Parliament. When Lord Simon took over as Lord Chancellor in 1940, however, he came to the role with an extraordinary political career already behind him, in which he had held offices including Foreign Secretary, Home Secretary, and Chancellor of the Exchequer. He had a rather different sense of what was prohibitively politically difficult. Hence, when a major case on the issue arose for decision by the House of Lords in the early 1940s, there was no pressing necessity for the House of Lords in its judicial capacity to make changes that it felt went beyond its judicial powers. And whilst it is clear that Lord Simon took a great interest in the case and sought to ascertain in advance what the other judges' preliminary views were, he exerted no pressure on his colleagues to make changes that were later accomplished legislatively. Indeed, his own speech in that leading case was happy to recognise the limitations of the common law solution. More subtly, extracurrial and biographical judicial materials can give a clearer sense of the values and influences that shape creative judicial developments. Thus, when Lord Hoffman spoke about the profound influence that Hart and Honoré's book on causation in law had on him as a student, and continued to have now, it showed both the length of time during which new legal developments may gestate and the variety of sources from which they might come. Similarly, those of us who were fortunate enough to hear the late Lord Roger lecture on some of the causation issues relating to asbestos-related diseases were left in no doubt about his acute awareness of the social problem that this had caused in his native Scotland. These insights are not to be found in the texts of judgments, but they serve as a reminder that judges themselves take on a role and are bound by conventions governing how they write, which can obscure the true nature of their engagement with the subject matter of their judgments. Only by exploring the unofficial sources can the full significance of their most important judgments be understood. I'll now turn to look at legislation. Here we might think the pattern of legal change should be straightforward. The statute sets out what the position is from the date that the statute comes into force. If only it were so simple. Statutes almost always have to make use of existing legal concepts and categories. One cannot make sense of the Occupiers' Liability Acts, for instance, without knowing who, at common law, is an occupier, an invitee, and a licensee. Similarly, the Law Reform Contributory Negligence Act affects only those situations where before 1945 contributory negligence had been available as a defence. But at least these statutes avowedly reformed the common law on its own terms. Other statutory initiatives can appear to be puzzling and retrograde steps. Perhaps the most conspicuous recent example in tort law has been Section 3 of the Compensation Act 2006. This provision concerned the question of whether a claimant could ever recover damages in negligence when, although the defendant had been negligent and the claimant had suffered damage, the claimant could only prove that the defendant's negligent conduct had increased the risk of that damage being suffered. Traditionally, the courts had held that proof of an increase in risk was not good enough. What had to be shown was that the claimant would not have suffered the harm if the defendant had been careful. The House of Lords had developed an exception to this rule, but in Barker against Chorus, it held that where a claimant could only prove that the risk of damage had been increased by the defendant, the claimant could not recover in full. He could only recover the proportion of his total damage that corresponded with the increase in risk. Section 3 of the Compensation Act reversed the House of Lords' decision by imposing joint and several liability on defendants who had increased the risk of harm. Claimants would now be able to recover in full from any defendant, and the onus would be on that defendant to find other defendants to recover a contribution from. However, the statute only applied where 4 conditions were met. These were that the defendant had exposed the claimant to asbestos, the claimant had contracted mesothelioma, the state of medical science made it impossible to say whether the asbestos exposure had caused the claimant's illness, and the defendant would have been liable in tort, at least in part, under existing principles. In other words, Parliament had created a special rule for asbestos-induced mesothelioma. If we analyse this special rule as an attempt to reform private law, it seems almost inexplicably inept, because it fails to engage with the broader principles articulated in the judicial decision that it reverses. It's not difficult to spot the gaps. If a claimant has suffered mesothelioma not induced by asbestos, the Act provides no protection. Nor does it help individuals who have been exposed to asbestos and contracted a disease other than mesothelioma. Then there are claimants whose diseases have not involved asbestos exposure at all, but who can show that the defendant's negligence increased the risk of their injury. They get no help from the Act either. So all these kinds of claimants who fall outside the terms of the Compensation Act appear to be in situations which are legally indistinguishable from those who are protected by the Act. But they remain governed by the rule that a claimant can only recover the proportion of his damage that is coextensive with the risk to which he was exposed. Those protected by the Act, by contrast, can recover in full from the defendant. Writers on tort law make no attempt to explain or rationalise this position. Indeed, there's perhaps a sense that the Compensation Act reforms do not really belong in a treatment of the law of tort at all. And I think that's unfortunate, because both the form of the legislation and the way it came about have a lot to tell us. An examination of the parliamentary history starts to suggest an explanation of what is going on. The statutory section was created at the initiative of several backbench MPs, most of them representing constituencies where traditional manufacturing industries had flourished. These MPs, it's fair to say, were not interested in the structure or consistency of private law. What they cared about was that many of their constituents would be unable to recover full damages for mesothelioma unless each of their former employers was still in business. As Lord Roger once powerfully pointed out, that was virtually impossible in industries like shipbuilding, which employed its workforce on very short-term contracts lasting only as long as there was work to do. Once one job was finished, the workers would move on to a different job at a different yard. In the drastically altered post-industrial landscape, very few of those shipyard employers were still in business. The statutory section, then, is an oddity, a reform of private law that fails as a reform of private law, but owes its peculiar form to the interests that gave rise to it. It illustrates, of course, that interest groups can influence the form of legislation. But I would argue that it does more than that. It shows that the lawyer's perspective is, in itself, often insufficient to make sense of legal changes. Legal materials such as the Compensation Act naturally form a central part of legal discourse, but they also feature in systems of communication which do not have law as their primary focus. What is happening in legislation like the Compensation Act is that the values and influence of other systems are determining the content of a rule that also has a place in private law. In other words, this is legal change accomplished by ignoring the sensibilities of lawyers. I wish I could ignore that. Resulting in content that strikes a dissonant note when placed next to more general common law principles. It's not simply a question of different language either. Identical language may be used in different discourses to signify different things. The point comes through particularly clearly in the Compensation Act reform. The House of Lords, when it concluded in Barker and Chorus that liability should extend only to the proportion of risk created by the defendant, made much of arguments from fairness. Thus, Lord Hoffman, with whom Lord Scott agreed, included a section in his leading speech headed Fairness. in which he stated that the attribution of liability according to the relative degree of contribution to the chance of the disease being contracted would smooth the roughness of the justice which a rule of joint and several liability creates. Lord Walker asserted that simple fairness required liability to be only in proportion to the risk created by the defendant. The main argument for reversing the decision, however, as expressed by the MP widely credited with accomplishing the reform, was that the law had to be put back to the position before Barker because that earlier position established fairness, which Barker took away. This is not just a point about fairness meaning different things to different people. It serves as a useful reminder that however much we might feel that as lawyers we have ownership of this system that we so. I had it originally written lovingly, but I think I'll change that to diligently service. And however much we might think that we have a uniquely expert understanding of ideas like fairness in legal rules, sometimes values and objectives that would be of only marginal importance to a lawyer dictate the content of those legal rules. It's tempting to see the Compensation Act reform as a straightforward clash between legal and political discourses, in which members of Parliament and the government responded with impressive speed and compassion to a judicial decision which, whatever its legal merits, was seen as causing a wider, unacceptable injustice. It would be a rather inspiring story. There may be legal changes that happen like that, but this, I'm afraid, isn't one of them. In the middle of a parliamentary debate characterised by cross-party compassion, a rather jarring note was struck by a Conservative Member of Parliament. He had just received a letter from a solicitor who had acted for one of the defendants in the Barker appeal. The solicitor had written in to point out that the litigation had in fact been instigated by the Department of Trade and Industry, which controlled one of the defendants. The solicitor said this: "It appears that the same government for which I was acting in what was then considered to be in the public interest has now apparently decided, following a clamour of protest, to legislate to reverse the decision which it itself sought." This, I think, rather complicates our analysis of the pattern of legal change. And I don't know about you, but for me, government heroically coming to the rescue when government has spent a lot of money on barristers to create the problem isn't quite the story I was hoping for. How the government had come to fund litigation that it then immediately sought to reverse was not really clarified in the subsequent debates. The Conservatives, implementing what was then unofficial party policy, were anxious to implicate Lord Mandelson, who had previously been the Secretary of State for Trade and Industry. But probably the truth is that nobody knew. Certainly the Minister herself had been taken by surprise by this revelation. And perhaps the explanation is simply that the political significance of the case had not been appreciated by the department in question. The approach to the Compensation Act that I've just set out draws on an underlying theme of this lecture, which is that official formal legal sources are inadequate in themselves to explain how legal change occurs. It is necessary to consult the reports of parliamentary debates, the proceedings of committees, even the correspondence between the committee members themselves and with outsiders to understand what is really happening. Here it should be emphasised that the parliamentary debates on the Compensation Act are unusually revealing. More often, parliamentary debates are the least informative of all of these sources. The real debates about the shape of the legislation have often taken place long before, between the parliamentary draftsmen, various committee members, and a range of outside ad hoc consultees. Indeed, In the 1930s, there's strong evidence that officials went to some lengths to ensure that the Law Revision Committee's proposals would have an uneventful passage through the House of Lords. Perhaps the nicest instance concerns the Law Reform Miscellaneous Provisions Act of 1934, which, amongst other things, permitted a claim to be brought by the estate of the victim of negligence. The reform did not permit the recovery of earnings that the deceased would have received in the future, but this caused little difficulty in the reform process. Just before the bill was due to be debated, however, the committee's chairman, Lord Wright, realised that there was a problem. By then, it was too late to change the text. Know how he feels. In the House of Lords debate, Lord Danesford, himself a former barrister, drew attention to the issue, but was curtly silenced by, I think, the rather wonderful remark, "This is not a subject where a fresh mind is appropriate." In fact, Danesford's fresh mind had identified precisely the structural weakness that the bill's architect was nervous about, and it might have been productive to explore it. But the legislative debate was not being conducted on that basis. The real decision about the content of the bill had been made earlier, elsewhere. It would be nearly 50 years before the position was properly clarified. The often uninformative nature of the parliamentary debates also underlines the need to go deeper into the archival sources, to investigate the source of law reform proposals and the creation of the institutions that brought them from idea to legal reality. Historians of private law have, at least thus far, not made the most of the English civil service's punctilious creation of memoranda and notes, which have been equally carefully preserved in the National Archives. To open some of these archival files is to enter a different world, in which there is anxiety about having a committee of 13 as an unlucky number, and where the diversity agenda, as we would call it today, calls for equal representation by men from both Oxford and Cambridge. Civil servants were also far less discreet on paper than they would be today. As well as providing an insight into the environment in which law reform was accomplished, these archival sources provide direct access to the real innovators in the reform process at a time when they are formulating, debating, and testing out their ideas. The study and appreciation of the full background to statutes is important and worthwhile in itself. But it also has a powerful part to play in situations where claims are made about the purpose behind a statutory initiative. Judges construing a statute frequently make assertions about motive and then proceed to justify their construction of a particular provision of the statute by reference to those motivations. To take one famous example, Lord Gough, in virtually the only case decided under the Law Reform Frustrated Contracts Act, said that the history of the Act was well known and that the Act forms part of the English law of restitution. He then drew on what he had identified as the Act's history and purpose in order to interpret its individual provisions. A closer examination of the reform process behind the 1943 Act, however, shows that the Act was not merely, as Lord Gough had suggested, stimulated by the observations made in the Fibrosa case in 1943. The initiative to reform the law went back far further than that, and legislation was being discussed before the Fibrosa decision took place. Nor is there anything in the Law Reform Committee's files from the 1930s and 1940s to suggest that the Act was conceived of as forming part of the law of restitution, recognition of the very existence of which would not really occur until Lord Gough's own book on the subject was published in 1966. What this example shows us is that in the same way that judges can create internal histories of common law developments, They can also create internal histories of statutes. As Lord Gough's approach to the Law Reform Frustrated Contracts Act shows, those histories may well filter out conflicts, confusions, and other random elements, and have a commitment to portraying a rational, well-considered trajectory. A corrective external history, grounded in the primary archival evidence, allows us to recognise such internal histories for what they are. The use of a full range of archival sources to illuminate the statutory reform process would hopefully be regarded as uncontroversial from an academic perspective. But I would like to conclude this section of the lecture by focusing on its potential practical impact, which recent debates about the use of statutory background materials have tended to obscure. Those debates have been sparked off by the controversial decision of the House of Lords in Pepper and Hart, and have focused on whether statements by MPs in the course of parliamentary debates can be used to construe individual legislative provisions. Almost in passing, it has been recognised that whatever the limitations on the use of parliamentary debates for construing individual provisions, the debates may be more freely used in order to establish the objective background to a statute. It is rather unfortunate that the two questions have been linked together because they raise very different issues. Whether a statement by an MP should be relevant to or even control the interpretation of an individual statutory provision quite obviously raises fundamental constitutional questions about the separation of powers. The use of parliamentary materials to cast light on the context and purpose of legislation, by contrast, simply involves a court informing itself more fully on an issue that is universally accepted as being central to statutory interpretation. Linking these two issues together implies that there is only a difference of degree between them in the caution with which the courts should permit reference to parliamentary debates. But surely, where the purpose of legislation is concerned, it should not be a mere question of permissibility. If we're serious about identifying the purpose behind a statute, the use of background materials such as debates should be the rule, not the exception. Nor should we confine our attention to debates. As I've explained already, parliamentary debates may well be very uninformative about the purpose of legislation. That does not mean that the legislation had no purpose. It means that the purpose must be sought elsewhere. Finally, for the final part of the lecture, I shall turn to consider academic contributions to legal change. Here, the theme that official sources are uninformative is, again, central. As Neil Duxbury has shown, the use made of academic writings by living authors was deliberately suppressed for many years by the convention that such works could not be cited in court. That peculiar custom has now lapsed, but other academic contributions may remain invisible. Thus, if the formal sources were to be taken at face value, the Law Reform Married Women and Tortfeasors Act of 1935, which introduced joint and several liability in tort, would appear to have been the work of the parliamentary draftsman. The archives, by contrast, show it to have been overseen by Harold Gutteridge and Arnold McNair, two Cambridge dons, to whom the draftsman sent his work, accompanied by the kind of little notes that characterise the supervisory relationship. I mean, of course, notes apologising for the quality of the work, for the delay in producing it, and fearfully anticipating a deservedly critical reception. Academics may, therefore, have roles in legal change which are not reflected in their official job descriptions. But academics also contribute to legal change by virtue of their teaching and their research, whether or not that research happens to be cited to a court. As if personal experience isn't enough, A glance at biographical and autobiographical materials makes it clear that academics and universities have a profound and long-lasting influence on receptive students. Thus, Lord Devlin could still vividly recall being supervised by Goodhart in Cambridge, and Lord Hoffman went so far as to say that if you are looking for the intellectual influences on the older judicial members of the House of Lords, the best way is to ask what was new and exciting in legal philosophy 50 years ago. Here I should emphasise, our concern should not merely be with detailed rules and specific ideas, but with how ideas are developed, expressed, shared, tested, and explored. That can only be gathered from non-traditional sources, such as lecture timetables, teaching handouts, letters, and biographies. To take just one example, Percy Winfield, the author of the textbook on tort, among many other works, lectured 5 days a week in Cambridge in the 1920s, 1930s, and 1940s, as well as giving supervisions on tort, Roman law, legal history, contract law, and international law. Apparently, he could never really accept why the university library had to be closed on Christmas Day. So it would have taken some determination to be a law student in Cambridge and avoid him. He also introduced problem classes, which had not been offered before. And as some of his surviving correspondence shows, he was constantly discussing legal issues with other colleagues, modifying his ideas in response to their suggestions. This emphasis on testing and developing ideas through discussion with students was in striking contrast to the traditional method of dictating a lecture or requiring a set text to be reproduced as an essay. It also captured something fundamental about the nature of change in the common law. Since there's no definitive form of words for any common law principle, change is effected by substitution. The older version of a principle is superseded by a version that somehow captures the idea better. Conversations about which formulation is better, and indeed what better means in this context, were far closer to the spirit of the common law than any teaching by dictation. Winfield's approach to teaching and learning clearly impressed itself on the generations of students who came into contact with him. The editor of Winfield's selected essays quoted a former student as saying that Winfield surely makes the law. This remark, of course, is a nice tribute, but it also has a deeper significance which goes to the root of this lecture. That is, that the reality of legal change is not accurately captured by the crude idea of a hierarchy of lawmakers with Parliament at the top, the court second, and academics nowhere. The picture is far more complicated, subtle, and interesting than that. Of course, if there is direct disagreement between Parliament, the courts, and academics, Parliament rightly prevails. But direct conflict in the development of private law is the exception. More commonly, the process is a cooperative, collaborative one in which the distinctions between politicians, judges, and academics dissolve. Part of the reason for that dissolution of formal distinctions is that the actors themselves acknowledge the collaborative nature of the process. Another reason is that individual actors are not exclusively members of particular categories. Rather, they assume roles which they may well hold simultaneously with others. Thus, Winfield may have made the law in one sense for his appreciative students. He may also have made it in the sense that his influence continued to be felt by those students when they went into legal practice and found themselves in a position to effect legal change. His work may have been relied on by barristers and by judges, whether or not that reliance is documented in the law reports. But he really did make the law when his contribution as a member of the Law Revision Committee was incorporated into bills that were passed without any substantive amendment in Parliament. Simultaneous roles may well be informal and only identifiable from archival sources. Gutteridge and McNair's unofficial supervision of the Law Reform Married Women and Tortfeasors Act provides a good example. Indeed, informal roles that leave no trace in the formal sources may be easier to combine than formal roles. For instance, when Mr. Justice Eadie, who was a former member of the Neal Committee, was called on to construe a section of the Defamation Act, which that committee had proposed, he found it necessary, and this is a kind of a quality I didn't realise one needed to be a judge, he found it necessary to instruct himself to forget everything that he knew about how the section had been drafted. But at other times, individuals have been able to reinforce their position as agents of change by capitalising on dual formal roles. Lord Simon, for instance, exploited his dual roles when, as Lord Chancellor, he cited one of his own judgments in a memorandum to the Cabinet, which he himself was presenting, showing the need for the reform of the law on the consequences of frustration. If we assume that a person's influence on legal change is defined by their official position, in other words, it will be impossible to perceive the true pattern of legal change. How then can we make better sense of legal change? I'd like to conclude by suggesting 3 key points. First, we need to appreciate the conventions and limitations of formal legal sources. These sources are not designed to give us a full picture of exactly how change has occurred. We need to be far more receptive to unofficial sources like judges' notebooks, committee working papers, and correspondence. Second, we should not expect a necessary correlation between the institutional models of change and the reality of its occurrence. To say, for instance, that statutes drafted by academics are parliamentary reforms is fundamentally misleading. We must acknowledge the complex relationships between the formal roles of individuals in the process of legal change and those individuals' actual influence on events. Finally, we have to broaden our ideas about who brings about legal change and how long it takes. A proper account of legal change does not just require the identification of the genesis of a particular modification or innovation. It requires an appreciation that those communications which have the effect of changing the law are in fact only a tiny subset of ongoing conversations about law. It also requires an understanding of the context in which the idea emerged and flourished. Changing law is a fundamentally collaborative activity, which involves a multiplicity of interactions, both instantaneous and long-term, between individuals, institutions, and texts. It is an activity that creatively exploits the tension between formality and informality, and between different systems of discourse. In other words, to get a full picture of the patterns of legal change, we need to imagine networks of communications and interactions between individuals and institutions extending over time, which create both the conditions for and the content of the legal change that we are trying to make sense of.
Thank you, Paul. I think everyone will agree with me that that was a fascinating insight into the realities of judicial decision-making, notebooks and letters, background to legal change. I've always thought that some of the initial ideas for law reform emerge over sort of wine-sodden after-dinner conversations among civil servants, and then they keep on running afterwards. And also about academic contribution to legal change. I think it was absolutely fascinating. You all had the opportunity to read it. It was beautifully crafted, elegantly argued, and faultlessly delivered. I think you will agree with me. It was a great inaugural lecture. Paul has said that he thinks he doesn't need to take questions this evening. He absolutely doesn't have to. So it is now, I better stand up for this, it is now my very happy, you stand up as well, I don't, I always feel I need a sword for this. Anyway, it is now my happy duty to formally inaugurate you, Professor Paul Mitchell, as Professor of Laws in the Faculty of Laws at University College London. It's wonderful.